Hello, America. I'm Mark Levin. Welcome to Life, Liberty, and Levin. And I want to thank you for being here this evening. This is a very, very important show. We're going to cover a lot of topics that affect you and your lives directly. We have two great guests, Mike Gonzalez of the Heritage Foundation. We're not only going to discuss critical race theory, but diversity, equity, inclusion, and environmental, social, corporate governance. This is consuming our society right now. What is it, and what are we going to do about it? Our second guest is the former Lieutenant Governor of New York, Betsy McCoy. Right now, a few weeks ago, the Biden administration triggered the destruction of the suburbs and the exurbs. And we need to get into this because it's happening right now. But before we do, I want to get into this story from the New York Times. The title is Prosecutors Seek Trump Lawyers' Testimony Suggesting Evidence of Crime. It says the Justice Department cited the crime-fraud exception to attorney-client privilege in demanding testimony from a lawyer representing former President Trump in his documents case. Now, this may say, oh, Mark, for God's sakes, my eyes are glazing over. We're getting in the weeds. No. This is a fundamental right. Have you ever had a lawyer, a divorce case, a contract case, a zoning case, any case? Well, you might one day. And are your communications with that lawyer going to be kept secret? Or are they going to be made available to the government or to the other side? This is crucial. This gets to the bottom of the matter, does it not? Attorney-client privilege is protected under the Bill of Rights. It's part of due process. Due process. You can't have due process without having attorney-client privilege. That is, your conversations with your attorney are private. Attorney-client privilege is the oldest privilege recognized by Anglo-American jurisprudence. In fact, the privilege may be traced all the way back to the Roman Republic, and its use was firmly established in English law as early as the reign of Elizabeth I in the 16th century. It's grounded in the concept of honor. The privilege worked to bar any testimony by the attorney against the client. Now, there's exceptions. If a client seeks advice from an attorney to assist with the furtherance of a crime or fraud, then the communication is said not to be privileged. So the prosecution goes to a judge and says, look, I've got evidence here that basically this is a ruse, that in fact the client is using the attorney to perpetrate an ongoing crime and fraud. But what's going on in the Donald Trump documents case? Is he using an attorney to perpetuate an ongoing crime or fraud, to obstruct justice? So I decided, let me take a closer look at this guy, Jack Smith, who they brought in from The Hague to appoint a special counsel to investigate Donald Trump on the document matters on January 6. Merrick Garland touted this guy. He's had two huge fails in his career as head of the Public Integrity Section of the Criminal Division before they shipped him off to The Hague. Let me talk to you about one first. This is the case that involved, and you may remember him, the senator from North Carolina, presidential candidate John Edwards. And very, very briefly, you might recall that he accepted donations of maybe $1 million total, $500,000, something like that from donors. And he used that money to take care of a girlfriend he had who'd gotten pregnant, to put her up in an apartment and pretty much cover up what was taking place through the presidential election. Well, in any event, long story short, Jack Smith decided to prosecute him, a violation of the federal election code. That money wasn't reported, the money violated limits, and on and on and on. Well, the jury found Mr. Edwards innocent, among other reasons, because Mr. Edwards said he relied on advice of counsel. And this kind of a violation requires specific knowledge that you intend to commit a crime. Well, if you're relying on advice of counsel, and counsel says, according to Edwards, that he was free to do this, it's kind of hard to convict somebody then of a specific intent crime when he relied on counsel. So what's this all about? Obstruction of justice is a specific intent crime. You have to know that you're intending to obstruct a grand jury, a jury, that you're intending to obstruct justice, that you're intending to commit a fraud or a crime. And the conviction is beyond a reasonable doubt. So what's going on here? Well, Jack Smith lost that case. And now he's trying to pierce the attorney-client privilege, this solemn privilege that you and I have. So we can consult an attorney and say, you know, I made a mistake, I did this, or, you know, this guy's coming after me for this, and, you know, here are my notes on that. You have to be able to prepare a defense. Why? Because otherwise you can't have a fair trial. Remember what you're up against. The prosecutor, particularly in the federal government, has endless resources, has all kinds of evidentiary things that they can do. You have to be able to defend yourself. The Constitution is set up that way. The Bill of Rights are set up that way. You're not supposed to be handing the prosecution all your information. Here's why I'm guilty. Well, then there's no point in having attorney-client privilege if that veil, as I call it, can be pierced from time to time or even often. So this is what this prosecutor is trying to do with Donald Trump. Now, what am I talking about? According to this news story, it was leaked to them. This Jack Smith, the special counsel, has gone to a federal judge who was appointed by Barack Obama to say this privilege that Donald Trump is using, that the lawyer is using, we've called this lawyer in before, Evan Cochran, and he's claimed attorney-client privilege. This privilege is simply being asserted to cover up ongoing obstruction, ongoing criminal activity. So why is Smith doing that? Because he got burned in the Edwards trial. And so he's figuring, let me get ahead of the curve and let me get access to what this lawyer, Cochran, and Trump have talked about, and I will use the crime fraud exception. Ladies and gentlemen, this is an abuse of the crime fraud exception to the attorney-client privilege. He has no evidence whatsoever, even though the filing is in secret in front of a judge, of what Donald Trump and this lawyer discussed. Unless, of course, he's violated attorney-client privilege with other lawyers who are surrounding Donald Trump. So far, Mr. Smith has called in 3 lawyers in front of his grand jury that represent Donald Trump in the documents case. 2 of them have already testified, and Mr. Cochran, who's one of his lead lawyers, a former federal prosecutor himself, he has asserted attorney-client privilege. And so what Mr. Smith is trying to do is break that down and get a left-wing judge who's ruled against Donald Trump on every single privilege claim Donald Trump has made in federal district court in Washington, D.C., to do exactly the same. So Donald Trump won't be able to defend himself. Now, that's appalling, and that's the problem. What else about this prosecutor do we know? When he was head of the Public Integrity Section, he oversaw the prosecution of former Virginia Governor, Republican, Bob McDonnell. Bob McDonnell was an extremely popular governor, but they used the bribery statute in Virginia, which is quite broad. They used it against Bob McDonnell, saying that he took gifts in exchange for meetings and that sort of thing. And he applied an extremely nebulous and broad interpretation to what official action is under the statute. Well, the trial judge, the federal district judge in Virginia, said it's fine. So under the reinterpretation of the bribery statute in Virginia, the former governor was found guilty. He was sentenced to 2 years in prison. And before he went to prison, he said, I need to appeal this. He appealed it to the Fourth Circuit Court of Appeals that said, we'll take a pass. We're not interested. Then they appealed it to the United States Supreme Court that said, well, we won't take a pass. We are interested. And thank goodness they did. They took up that case, and you know what they found? They found that Mr. Smith's reinterpretation of corruption in the bribery statute, the quote-unquote official act language, was way too aggressive, was way too broad. And there were 8 justices, as I recall at the time. Every single one of them voted in the majority the decision written by Chief Justice Roberts, reversing the case, remanding it back to the Fourth Circuit, leaving it up to the Department of Justice if they wanted to retry or drop the case. And the Department of Justice dropped the case. Why? Because they didn't have a case, but for Mr. Smith and his interpretation of a statute that was so wildly out of control. So Merrick Garland picks this guy after they had sent him off to The Hague to go after genocidal murders, to bring him back. after these two epic fails. And what does he do? He's got a widely broad interpretation of obstruction, I can tell. I don't have to read tea leaves, I see what he's doing. And he wants to make an obstruction case, but he wants to violate a principle that applies to all of us when it comes to justice and lawyers, the attorney-client privilege. And it's in front of a judge who has ruled against President Trump every single time. An Obama judge. She is the judge that hears grand jury matters and motions related to it. And obviously the prosecution knows this. So I bring this up to you because it's, with everything that's going on, it's getting lost in the static, but our civil liberties are being violated. Our Bill of Rights are being violated. If they can do this to Donald Trump, or if they can drag lawyers in front of grand juries, violate the attorney-client privilege, take their iPhones and cell phones, take their testimony, take their emails, take their texts, well, what's left? They've gone after Rudy Giuliani. They've gone after John Eastman. They've gone after Joe DeGenova. They've gone after Victoria Tonsing. They've gone after now Evan Corcoran and two other lawyers related to the documents case. Have you ever seen anything like this in your life? And they claim to be defending the Constitution. And they claim to be defending documents and the security of the nation while they're steamrolling the Bill of Rights. Attorney-client privilege is crucial. The crime-fraud exception is a rare exception. It's not supposed to be regularized or routine, or we cease to have the ability to have effective representation of counsel. Mass murderers, terrorists, what have you. Attorney-client privilege is rarely pierced when it applies to them, and yet it's been pierced in a serial nature when it applies to Donald Trump and Republicans, Republican legislators, and Republican legislatures.
Want to see more Mark Levin? Go to LevinTV.com and subscribe now.